question is from Rajesh Kumar, who says whether scope of this act applies to data collected from vendors, such as PAN and GST of vendors. If PAN of vendors is uploaded in MSME one form, is it violation under the act?
So, Rajesh, if the vendor is an individual, then taking their PAN, GST, everything will become, because it become personal data. If the vendor is a company, then this doesn't apply to the data of companies. So it's an individual data that we're talking about. But yes, the vendors could also be proprietors, individuals, etc. So to that extent, it will become a personal data, and you will have to have reasonable safeguards. But if you're reporting certain data in MSME one form, etc., that's a regulatory requirement. So there's no violation to that extent. Yeah.
Okay, thank you. Next question we have from Mangesh, who says what companies exactly need to do make sure that they are compliant with DPDP Act. Example, under IT Act, there was need to maintain policy and get audited every year by the government. Likewise, how companies can be compliant with this new law. I believe this is something that we have already answered with all the compliances that they'll have to take. Impact assessment every year has to be done. So we can skip this.
Yeah.
Going to the next question by Parul. Consent manager is applicable on all the companies.
No. So that's where Parul, it differentiate consent manager looked like earlier that it is a position in the organization, but it's a different kind of a business model which will be notified by central government, and they will be like intermediaries to take consent. So it's a different one.
Okay. Moving on to Rajiv asks if a consent manager is a third party, then how will professional firms handle such data which they gather from their clients? Is there an exception?
So remains to be seen, Rajiv, how consent managers come into the picture, what kind of platforms do they use, how will they aggregate processes between the data fiduciary, the data processor, the consent manager, the data principal, all that remains to be seen. How will data flow from one point to another, and how will consents flow, all remains to be seen. Maybe the consent managers do not get the actual data, they just get the consent, maybe the type of data and the consent only, not the actual data. So suppose you log onto a platform and say, I consent to you or I consent to Swiggy, for example, to take 1 2 3, and that consent you fill at another platform which is not Swiggy. So something like that scenario I'm imagining. Yeah.
Next question is by Mohammed, who's asked DPBI will be constituted where? I believe this was something that you answered in the
Delhi.
beginning that,
Yeah.
yeah, in Delhi.
Start with
So,
Delhi. Yeah.
yes. Ashish asks, how will real estate, bank, and telecom companies be bound by the use of our data? They always state that they have got the data and hence calling us to buy their services. They do not follow DND and DNC. So, how will this be covered?
No, everybody is covered. Nobody is exempted. Real estate, bank, and telecom, whatever are their statutory regulatory requirements, that of course they have to maintain and do. But it doesn't mean that they get a unfettered right to spam. In fact, one of our client companies recently got a notice from Geo on outbound calling from a private number, and I was very impressed by those notices, and the fact that okay, the actions are being taken, and show cause notice was asked, and somebody would have complained that okay, I received an unsolicited call from a private number, not from a telecalling registered number. And so I think all these things are becoming DND, DNCs are becoming better, and the enforcements are becoming better. And after DPDP, I'm sure these regulators also and these agencies will become sharper, better, quicker, agile. So I think let's look for better times. Yeah.
We have a good question from Weber who asks, can we request telecom like Airtel to delete my call history? Is that possible?
May not be, because in the telecom regulations, if they are, I'm not a telecom expert, but if they are probably required to maintain the CDR, the call detail records, because those are also sometimes required in investigations, etc., etc. If there are some specific try regulations, then you may not be able to ask that. Yeah. So it's a legal, if it's a legal legally mandated by them to keep CDR up to a particular time, then you can't request it.
Okay. Next, Raj Kiran asks, details shared as employee verification is also considered as breach of data. So yes, just like Dr. Sumit answered before, if any of the employees' data is shared further for verification, you'll have to ensure that it complies with the DPDP rules and the Act. Next question is from
It has to
Ashish.
comply. It won't be a breach of data just by sharing, because organizations will now ensure that they take consents and then they do the necessary agreements with the data processor, the agencies, etc., then it won't be a breach.
Okay. Is Ashish asked, is the sender of email containing some important related information to some other person is covered here? How will this be regulated? Because by the time it comes in the knowledge of a aggrieved party, the damage is already done.
Not too sure of the question here, but if somebody is breaching and I get to know, then I'm not responsible for it. But anyways, if for example I receive an information erroneously, inadvertently, or something that I shouldn't have received, and if the sender request for a deletion, I must delete it. Even if he doesn't request, and if I feel that this has come to me in error, I think it's a prudent practice to sort of delete it and confirm it to him that okay, this looks like you erroneously marked this to me and I'm deleting it, kind of thing. That should be a best practice.
Okay. Next is there any registration for data fiduciary with the government?
No, the data fiduciaries is all the companies, so it would be like probably 17 lakh companies, and not just companies. I mean, they could even be the other forms of businesses and even the proprietorships, there's that. So, crores of data fiduciaries. So, there's no registration requirement separately.
Okay. Data consent manager and processor must be third party entities or can be appointed internally by the organization.
No, they are third parties. Consent managers would be intermediaries, as I said, and processor would be a third party. Yeah.
Okay. Chandresh asked a question. What is meaning of publicly available data? Can financial data fetched from MCA by fintech company termed as publicly available
Yes, yes,
information?
yes, for sure. So MCA reportings and MCA in data, all this publicly available data, and that is well in public domain. Yeah.
Okay. Next question says company asks for emergency contact number and blood group name to employees for office ID printing, which is also a statutory requirement under SNE Act for Maharashtra. So does company needs to take consent from employees for asking employees to share
Yes,
personal and sensitive information?
of course. So or emergency contact, blood group, all that is now personal, medical, and sensitive. All that. Yes, consents are required.
Kiran asks when it will be made applicable to bank. Shall they wait for regulators RBI circular?
When the DPDP will be made applicable to the banks, you mean?
Yes, yes, yeah.
I think banks there's no specific exemption or special provisions for banks right now. Banks, I'm sure, would be notified as a significant data fiduciary. So I think for everyone has been given 18 months, in different phases that I explained. So it's banks are no exception here.
Two, three people have asked a question that will we be sharing slides. So we'll be sharing links of the Complinity social sites. You can go there and can see the recording and access the recording from there of this present session. It will be available. Moving on, Apurva asks, will legitimate interest not be a legal basis for processing data in case of employment?
Legitimate interest is a legal basis. However, still consents would still be required. Yeah.
Okay. Are consent provisions applicable even for previously collected digital personal data or with retrospective effect? Yes, that's correct. You'll have to take the consent again, even if
Yeah.
you have collected information even
Right.
before the gets in.
Right. Right.
One attendee says, should companies solely collecting employee and vendor details such as name, address, GST also create a privacy policy, etc.? I
Yeah, you should.
think
These privacy policies are anyways part of the IT Act also. So the IT Act, while 43A has been repealed, but the other of the balance IT Act remains, and privacy policy anyways is a good mechanism. And every organization would anyways be collecting some data. I think it's for them to see what kind of data, and therefore privacy policy should be the starting point. Everyone should look at it.
another question is Companies Act and IT Act requires to maintain data for a certain period that is 8 years. What is to be done in such case if request for deletion is received in 2 years?
No, again, the since the law asks to maintain the data for 8 years, etc. So that will come into the legitimate exceptions.
Okay.
Yeah.
Ashish asks a question, who shall be the auditors in this case? What is there in it for practicing
And
profession in
in
this
this,
act?
Surbhi, just to add in the
Yeah.
previous question, see, we must not confuse or any data with personal data, because here what we are talking of is just personal data. So when we say 8 years, there's that 8 years is mostly like financial records, balance sheets, and maybe the vouchers and all those things. So any transaction, vouchers, commercial transactions, invoices, purchase orders, that is not personal data. Personal data is, as we said, related to an individual, which can identify the individual. So I think the scope of that is personal data and not any data which the organization is churning.
Okay.
Yeah.
Who shall be the auditors in this case? Where what is there in it for practicing professional in this act?
So
So can
which practicing professionals are recognized? This is on the bodies of ICSI, ICAI, etc. to see that what kind of recognition the professionals will achieve or receive. And auditors also, again, depends on the rules, who will be identified as the auditors. Maybe the statutory auditors get some rights. Maybe the secretarial auditor gets some rights. So it remains to be seen.
yeah. Sanvi says, can consent obtained through shrink wrap or browse wrap agreements be considered free, informed, and specific? So I believe just like Dr. Sumit clarified before, if it is just moving ahead with the content, it should not be there. Specific tick boxes should be there. They'll have to clearly agree and provide their consent. Only then it will be valid.
Yeah,
Right?
and historically, Sanvi, the shrink wrap agreements are so detailed and nobody reads it. It means even as lawyers, I am sort of guilty of sort of simply accepting and moving on, because who wants to read a long one? And anyways, we didn't have a right to deny, and if you're using the service, so but that prominence of the consent is important, and that change I think we must see.
Yeah. Why employment related data will not be covered under Section 41B, that is legitimate uses of DPDP Act? Why only consent is
Okay.
required?
Okay, we'll
Yeah.
park this question. I think the question is valid. It is indeed a legitimate use, but whether consent is not required, I myself have to look into it specifically. So we'll park this question and see. Yeah.
What is the difference between data fiduciary and significant data fiduciary?
Yeah. So data fiduciary is anyone who has a purpose, who has a purpose to collect data, is a data fiduciary, which is any company. Significant data fiduciary will be notified by the central government based on volume and risk. So larger level entities will be significant data fiduciaries.
Okay, if personal data are transferred outside India, if please specify the destination country and the specific purpose for which data is being transferred. I
So
believe this.
currently, there is no prohibition of data being transferred outside India. However, there are sections which say that central government may notify certain countries or certain purposes where data cannot be transferred outside India, and one can expect notifications or circulars or rules on that. Additionally, there are certain other regulators and other regulations where certain data localization requirements might be there. For example, the BFSI data, means the banking and financial services industry, data related to banks, etc., or even say telecom data, even I think the printing, not the printing, the media industry. So there are certain regulated sectors, and maybe because of security, sovereignty, those kind of things. So if there are other regulations which mandate a data localization, that also has to be complied with. That is point one. Second, even within the DPDP Act, the central government can notify in to which countries what cannot be transferred, and that will remain to be seen.
Dr. Sumit, we have a lot of questions. So maybe in next 2-3 minutes, we'll try to cover most of them. Rest we'll cover over emails or we'll send them personally, the
Sure.
responses.
Sure.
One person, Rohan says, suppose I'm a company and a data principal asks any of my employee to delete the data which the company had collected previously. Will this be acceptable? Does the company needs to act on this?
Sorry, I couldn't get it. Who has asked this question, you're saying?
Rohan.
Okay. Yeah. Can you repeat the
He's,
question quickly? I couldn't
he
see.
says that I'm a company and a data principal asked any one of my employee to delete the data which the
Hmm.
company had collected previously. Will
Hmm.
this be acceptable? And does the company needs to act on this?
I am a company and a data principal asked any of my employee to delete the data which the company had collected. Will this be acceptable? Does the company? Yes, the company has to act on it, because it's like a withdrawing of the consent. Uh, okay. Consent, but consent managers will be different, no? Consent managers are intermediary. Yeah, so okay, so my team was also besides me, and Drivya, let me first thank her to help me in the research of the entire act and the presentation. So she has something to add here. She says that you cannot ask any employee to just delete the data. Whoever is the consent manager, either it's an intermediary or if it's an internal thing that remains to be seen, that it has to be routed through them. But even if then the company has a legit purpose to keep the data, because if the employee is continuing and the legit purpose to keep the data for some purposes, then those things have to be seen. So it may not be, it's not an easy question that depends on facts and circumstances of the case whether data can be deleted or not.
Thank you, Durga and Dr. Sumit.
Yeah.
One question, Rohit asks, so we have supplier agreements in China. Will particulars of those suppliers like address, local tax numbers, registration numbers of companies be treated as digital personal data? If yes, what as an supposed to do?
So, it's a good point and brings about a very good point that these suppliers are maybe foreign individuals. Let me assume these are individuals and they are foreign citizens of China, and this is their data. So their data, which we get here, is not covered under the DPDP Act because it's protecting the Indians' data. So Indians' data going abroad or foreign companies accessing Indian users' data is covered, but foreign citizens' data, even if you are sort of collecting their things, incidentally, that's not sort of within the coverage right now. Yeah.
Suchi asks, we cannot delete employees' data even after they leave. How to mention that employees have the option to delete the data?
Yeah, that's what. So Shuchi, that's exactly what why I also paused in the earlier question. It's a tricky question. One has to sort of get more into detail that employees' data cannot be so easily sort of deleted. Something which was obtained for a legit purpose through consent. They cannot simply say, "I withdraw my consent, delete everything." So I'm sure either the rules or something will give more exceptions to these things. Yeah, for withdrawing. Yeah.
Sudhit is asking whether privacy policy is no longer required. So, just like Dr. Sumit mentioned, 43A is repealed. The rest of the Act of IT rules remain as is. So, privacy policy will be required.
Yeah.
Sachin says, yeah, you want to add something?
Even in DPDP, privacy policies are required. So yeah.
Okay, okay. Sachin says, any compliance requirement for filing of any returns, document filings, or declarations to authorities?
Not till now, but I'm sure something will come in other rules and all, so that remains to be seen.
I think, Dr. Smith, we can take a pause now and we would be answering the rest of the questions either through email or personally reaching out to them.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.